obviously we're in the age of AI now, as we are all ready for their sentient takeover. Before that happens, we've seen a lot happen in art where people are utilizing AI to generate both physical art, digital art, and recently I think it was, I can't remember, like some big DJ. I don't know if it was like Martin Garrix or David Guetta or something like that. Like
it was David Guetta.
It was David Guetta, yeah. Created the AI generated Eminem sample in which he used Eminem's voice, but it wasn't Eminem. And I'm curious, like, what your thoughts are on that whole trend, the legality of it, and what you envision kind of future laws being imposed to protect artists like that, because it's really, it's almost like copyright criminals all over again.
Yeah, it's a like very timely question. We've been working a lot on that lately. There have been a couple creators, not music creators, but visual artists who came to us and tried to register works. And I said, like I started out saying, like I don't do copyright registration. I don't actually do it, but I do the policy around it sometimes. And we had two artists, who said, we created this work using AI and we want to register it. Can we? So the first one that came through, we said no. It must have a human author to be protected by copyright, and pointed to cases in the past saying that, well, there was this case about a monkey selfie. You might have seen that in the news because that was kind of funny, or a monkey pressed the trigger on a camera and took a picture of itself. And then and PETA brought a lawsuit for the monkey and lost. And the court said, oh, you have to have a human author. Same thing with, there was a case involving a garden as a sculpture. And the court said, well, you need a human author, and this is a work of nature, and so you can't get copyright protection there. And there was another case that someone said, like, I didn't write this book. A lot of these like hypotheticals are kind of like law school hypotheticals, where people say like, well, what if? But these are actual cases. And this one was, they said, I didn't write this book. A divine being came down to me and told me what to write, and I just scribed it, so I wasn't the author. And the court said, well, like, you could be the author, but you're not, because you said this divine being wrote it. So, we took that logic. We took some discussion of earlier cases of like, oh, is a picture, like a photograph, copyrightable? And there's some language in like older cases that says like, yeah, despite using a machine, like that doesn't make it not copyrightable. What makes it copyrightable is that there's a human author. And so we told the person trying to register this work, nope, these cases and this logic say no. And he sued us. And so we're going through that litigation right now. We said, very similar arguments in our legal filings to this point. But the other thing that we did a couple weeks ago was issue a statement that said, like, listen, it's always been our standard that you need a human author to protect a work. AI that's autonomous, or AI that you put like a word prompt in, but you don't like create yourself, it's not going to output a work that's protected by copyright. And so we reiterated that and gave some guidance about, hey, if you're trying to register a work, tell us the pieces that have been generated by AI, because it's nothing new to take stuff that's not protected by copyright, add something to it, remix it, rework it, whatever, and then get copyright protection. I mean, like, you can, if you try to register like a red circle, we'd say no. Like, obviously that's like a building block for like drawings and stuff like that. But if you add 10 red circles and there's a blue circle and there's a yellow square, and like you just remix it in a way that was creative, it was a human that did it, that would get protection. So we'll probably see more discussion about like where that line is in different circumstances going forward. But it's also something that like Congress is really interested in, and the creative industries are really interested in. And some people think that, well, AI should get some sort of protection, even if it's not copyright protection. We should create a law that like induces and encourages people, gives them an incentive to like invest in AI to create creative works. They should get some protection from that. Other people say that, well, even if that's true, AI is trained on copyright protected works already, right? Like either we shouldn't let them do that, or if they're going to do that, we should get like a royalty for it, right? And then some other people say like, well, no matter if it's trained on works or not, if the output of the AI is infringing somebody's work, we should be able to sue them. And so we've seen a couple of cases already. Getty Images has brought lawsuits against some AI companies. And in that case, the circumstances are a little different because you could actually see the Getty watermark. They didn't take rules about language like I before E, except after C, stuff like that, and then like have a computer figure out what people like or what makes good grammar. But they actually like copied some works, and the copy was close enough that like the watermarks were in there. So there are some cases about that right now. I'll say the last piece though that is maybe interesting is a lot of the world has been talking about NIL rights since college athletes were able to do that. But one thing people might not know is that there's this other part of law that isn't copyright at all, but it's called the right to publicity, right? Similar to your name, image, likeness, things like that. There is not a federal right to publicity law. It's all state law. And so now there's some discussion about whether there should be a federal law that's, in a way that kind of looks like the states, but can be applied uniformly. And so that type of law might apply in a circumstance where someone says, write me a song in the style of Taylor Swift, right? Like even if there is no actual copying, or if there's, hypothetically, there's no copyright issues involved and the inputs are outputs, if you're writing a song in the style of Taylor Swift, are you, taking something that would be her right and violating it? Well, maybe depending on the circumstance, but maybe depending on the state, but they're thinking about it doing that federally.